Good morning, participants. Great to have you with us this 16th day of July. You're welcome for our masterclass today, which is on intellectual property. We shall be taken through this masterclass by Elvine Apiyo. Elvine Apiyo is an advocate of the High Court of Kenya. She's also an assistant registrar of Trademarks, and she has conducted plenty of such trainings. Just as we get into our day today, we will commence with the national anthem. We will recite this as our prayer as we begin today. O God of all creation, bless this our land
and nation.
Justice be our shield and defender. May we dwell in unity, peace, and liberty. Plenty be found within our borders. Just a little overview of what we shall have today. We have 3 sessions to take us through the masterclass. We have the first session, which is this one. We have an introduction to industrial property, patents, designs, and trademarks. Then we'll have a break, and then we'll have the second session at 1:30 p.m., which will run until 3 p.m. We'll be able to look at dispute management and case studies. And the final session will run from 3:30 up to 5 p.m. This will be having a discussion on, how do we position ourselves as mediators to be able to serve within the sector and the industry. I encourage you as we go along to be able to put your questions and comments in the chat, and we'll be able to get on with that. Elvine, good morning. How are you?
Good morning. I'm fine, thank you.
Okay, so just before you take us through this session, just, something that the participants might be keen to know is why is this an area that is of interest to you personally? And then once you take us, you're able to let us know why this is an area of interest to you personally, then you may proceed with your presentation. Thank you, Elvine.
It's a trick question. I don't know what to say. I think it's part of what we learned in school. And I got to delve into it either by mistake and loved it passionately. Once I was doing the course in school and did a dissertation on it, and yeah, just out of research, found out that intellectual property is what we eat and breathe every day. And yeah, and so that has become a passion. I have been there for almost 13 years,
okay.
Not looking back. Yeah, so that's why.
Okay, thank you very much. We are free to get on with you, so the session is all yours to take us through. Karibu sana.
Asante. I will share my screen. I have a presentation. So let me. Just 1 minute.
No problem. As Elvine is getting settled, I would also like to mention that for this particular session that we're having today, which is a masterclass, we shall be giving a certificate to those who attend the sessions. You will need to attend all 3 sessions in order to be able to get the certificate. So that's just for your information. Thank you very much, and Karibu, Elvine.
Okay. I hope I will be able to keep time. Yeah. I don't know if it will be too much to, can you see it?
Yes.
Okay. Anyway, so today good morning, everyone. It's very weird in these times to speak to a screen, but I hope it will be as interactive and interesting as we go along. So anyway, so today we are dealing with industrial property. And so I'll just dive into it. We will begin with definitions. Our first session is on introduction. It's an introductory session for us to be able to understand and underscore the different types of intellectual property. So intellectual property can be defined, I don't know if it's, can you be able to see or should I reduce the?
Elvine, we can be able to see.
I think you can see.
Yes, we can see.
Okay,
yeah.
Fine. So then intellectual property mainly is intangible property. As we know, property proper, whatever is tangible would be land, would be, anything that you'd own, a chair, a table, that would be tangible property. But in this one is intangible. It entails creations of the mind. I think that those are the key things to look out for. It includes patents, trademarks, industrial designs, then literary and artistic works used in commerce, used in business, in other words. So intellectual property is divided in two main categories. And I think this is one of the misconceptions that people would have in terms of the intellectual property is the whole body of what I've talked about. It includes in this industrial property, literary and artistic works is what we know as copyright and related rights. And then we have plant breeders' rights. So that's what encompasses intellectual property. So industrial property is patents, utility models. We'll be looking at them specifically, industrial designs, trademarks, and geographical indications. Copyright is what I've talked about. Literary is just written. It's a big word, but a simple word. Novels, poems, anything that is written that has to be described in a tangible form. Artistic works, what we know as paintings, drawings, photographs. Related rights are rights such as performers' rights, producers, and broadcasters. These are other rights that arise from a copyright, not necessarily being the person who authored, but probably if I sang a song and someone else is performing, then I would have performers' rights if I'm dancing to the song and things like that. So intellectual property similarly incorporates what I'd already said, plant breeders' rights, meaning anything that is related to plants, any varieties that someone would crossbreed and state that they are new in any form, then you would have rights under this plant breeders' rights, and it's under did I say copyright is administered by the Kenya Copyright Board, known as KECOBO, and plant breeders' rights are administered by the Kenya Plant Health Inspectorate Service. Anyway, so where do we get the mandate for us to, protect and support and promote intellectual property? The anchoring law is the Constitution. Article 45 states that the state shall support, promote, and enhance the intellectual property rights and protect the intellectual property rights of the people of Kenya. So then the state, Article 11.1, so this is what Kenya industrial property, this is what gives us the mandate for us to protect intellectual property rights, Article 45. Article 11.1 also gives the state, or rather the people of Kenya, the right to promote their national and cultural expressions. Article 69(1)(c) and (e), they mandates the state to protect traditional knowledge and genetic resources. So there's a Traditional Knowledge Act. We shall get into all the intricacies as we go along. Article 260(c) includes intellectual property in the definition of property. So this is what anchors what we are administering in terms of intellectual property. So then we look at what Kenya Industrial Property Institute does. Kenya Industrial Property Institute is a state corporation established under the State Corporations Act, and that governs state corporations, which we loosely know as parastatals, and the Industrial Property Act of 2001. I will be using KIPI. KIPI administers 2 acts of parliament, the Industrial Property Act 2001 and the Trademarks Act, Cap 506 of the laws of Kenya. So then that would be the difference between KECOBO and what KEFIS does. KIPI handles, that's why we are the Kenya Industrial Property. If all of us were together, then it would be the Intellectual Property Institute or office. But since we are separated, copyright and related rights are handled by KECOBO. So then, and plant breeders' rights are handled under KEFIS. So it means then we just handle industrial property. So we are primarily charged with the responsibility of granting industrial property rights, which I have explained the difference. KIPI's mandate encompasses considering applications for and granting industrial property rights. We screen technology transfer agreements and licenses. We talked about property. It's only that it's intangible. This is also property, meaning once someone acquires the rights, then they can be able to transfer their rights. Just as we would sell land, we would transfer, we would license, provide to the public industrial property information, which is what we are doing today, creating awareness for technology and economic development, and to promote inventiveness and innovativeness in Kenya. So basically, this is our mandate as anchored in the Constitution. So then what exactly are these industrial properties? What it includes is patents. Many of you have heard about patents, trademarks, industrial designs, and geographical indications. Then we also have something we call trade secrets. I will not concentrate so much on trade secrets, but I will explain it at this point. As the name suggests, these are secrets in trade. You know, I think one of the best kept secrets is the Coca-Cola formula. We hear that there are only 3 people who know each of the parts of the formula separately, and they never meet. And so it's one of the best kept secrets. So it's a converse of what we are talking about. When people keep things in secret, then it means we can never ever know what exactly they're using or what kind of technology they're using in terms of what I'm going to explain in patents. Patents needs disclosure. So then it means when you keep it secret, it means we will never protect it. So only one person gets to know about it. So the positive is that you get to protect it for a long time. Every of these industrial properties that I've mentioned have a time limit. But if you're able to keep a secret well, as I've said, one of the best kept ones is Coca-Cola. It means then you'd never have time as a barrier. But then again, if someone opens up, if one of those people would be able to disclose that secret, then that's it. Your secret is gone and your protection is gone. So then I'll go into the details of each one of them, just for us to be able to understand. And it's important because when we do not understand, even when we are looking into mediation, and as we've talked about property, and we are giving protection and we are giving exclusive rights to people, then it means then there would be a bone of contention, and that's where mediation and any other alternative dispute resolution mechanism would come in. So then it's important for you to know the aspects that entail this dispute. So for beginners, we'll start with a patent. I will be very simple. I hope we are understanding. I do not want to put a lot of legalese so that we can be able to understand. A patent is a certificate or a document granted to give exclusive rights of an invention. An invention, on the other hand, so when we say it's a certificate or a document, it's granted by a competent authority. And that competent authority in this country is KIPI. So KIPI would give you this patent when you have given, and we give you exclusive rights, meaning you are able to remove any other person. Exclusive means it's just only you. These are private rights given to individuals as a way of government, giving you an assurance that you're able to use that which you have spent a lot of hours in inventing, so that you disclose to us the technology, we give you protection for a certain period exclusively, meaning that if anyone wants to use whatever you have come up with, they'd have to pay you, they would have to seek your permission. And permission most often is, grants of either selling or giving a license. So what is an invention? An invention is a solution. So we are saying that whatever you're inventing is a solution to a specific problem in the field of technology. So then if we are people, for instance, when the Wright brothers thought about the aeroplane, maybe people are walking long distances and someone thought about that's a specific problem. That distance is a problem, transportation is a problem. So we come up with a solution to give fast transport solution for people to be able to connect, interconnectivity around the world. So they solved a problem in a field of technology. Then a trademark is a sign that is capable of distinguishing the goods or services of one enterprise from those of other enterprises. It's often a badge of origin, meaning that when I look at a trademark, it is a sign that tells me where the product comes from. And it gives me a sense of, who, if I look at Coca-Cola, I would think, okay, it's Coca-Cola company that's producing this. If I look at a sign, whether it is Shell, it tells me much more about the goods, from distinguishing it from one party to another. A copyright is a right given to creators of literary. We have talked about what literary and artistic works are: paintings, photographs, music, verses, and books. Plant breeders' rights are also exclusive rights. All these rights are exclusive, granted to creators or inventors of, plants and new strains of varieties that are also protected. And we talked about KEFIs just a few minutes ago. So utility model, and I'm defining this so that when we go along, and even as we do the other sessions, then we are able to distinguish and know what is industrial property and what entails intellectual property, and what each of them entails in terms of what conflicts could arise in administration and in management of these rights. So a utility model is often referred to as a petty patent. It qualifies if it's new and it's industrially applicable. The term ends after the 10th year. A patent we have talked about is a certificate, and I'll go into the details of a patent. So it's a small patent. We call it a petty patent. But more or less, what is the difference is that when it's, and I'll explain it. Let me explain it because these are just definitions. I'll explain it when we are talking about patents. Industrial designs is an overall appearance of a product. Anything can be a machine, a hand, it could be a hand tool or a machine, resulting from one or more visual features in terms of shape, in terms of configuration, pattern, or ornamentation of a product. And industrial design, when we think about designs, we buy things because of how they look and not the functionality. A patent is more on the function of a product. And that's the difference between a patent and an industrial design. An industrial design is merely for the aesthetic look. When I buy my specs, we all have lenses, probably because you're short-sighted or you're long-sighted. That was the solution to the problem of eyesight problems, or rather for eyesight. And then if I'm to buy my frame, I would buy it, and you'd realize that there's some people who would have different kinds of frames based on how they look, not on the functionality. So when I just buy things because I think they're beautiful, not necessarily on how it works. So that goes to, it goes to everything. Our cutlery, bottles, the function would be to hold water or to be a receptacle to hold liquids. But then again, when we now look at the design, then we are just looking at our clothes. It's just appearance. We are looking at the visual effects. We are looking at pattern. We are looking at ornamentation. When we look at cars, when we look at our phones, when we look at our laptops, our chairs, when I am using a chair because I have a problem with my back, then that is function. That would be a pattern. When I look at it just for the overall appearance, as much as it's functional, it's also beautiful, it has a specific design, then it can also get protection as an industrial design. Industrial designs are protected for 5 years, and they're renewable twice, just because designs are they're very dynamic, they change very fast, and so therefore protection is a bit shorter than the other protections, but it can be protected up to, that means it can be protected up to 15 years. So an industrial design must be new. It must not be disclosed to the public anywhere in the world. So you're not going to look at a design probably in the UK or in the US, then you come and say that it is your design. It has to be new. We have databases that we search and check whether to see before this came, before your application came, whether there was anything prior, any design prior to that has been disclosed. Disclosed meaning anywhere, in any publication or anywhere in the world. The application for industrial design is accompanied by the form. There's a specific form, there are drawings, there are photographs or graphic representations of the article embodying the industrial design. So we need to see it, we need to see if you're telling us it is lines, it is shape, it's on you need to show us exactly what is new in that design. So they are registered and published. So then, as we say in law, that patents, the provisions of patents apply with modifications. That's what mutatis, with necessary modifications. That's what mutatis mutandis mean in terms of for industrial designs and utility models. So everything applies, but with necessary modifications. I would just want to give a visual view, and I used this example so that we can see that an industrial design for one product or more or less the same products can just vary completely. You can look at the shape, you can look, and it could be the same function, we just want weights. But when we look at each one of them, they are different, you know, so the aspect of the function would go to a patent, but when we look at the ornamentation, the shape, the configuration, some are gold, maybe for people who are from my village would want to feel that they are more sophisticated. You know, it's more or less, and some of them, because of the shape, probably it would assist in the functionality. Once it goes into the functionality, then it moves to become a patent, but then it also qualifies as an industrial design on the basis that it is also beautiful because of its ornamentation. We also talked about an aspect of geographical indications. Geographical indications are anchored under an agreement we call the trade-related intellectual property aspect. And it's an agreement that Kenya is a signatory to. Article 22.1 defines we call them GIs, geographical indications, if you want to look sophisticated. The indications, it generally identifies a good by where it originates from, meaning it's a region, it's a locality. For instance, if I say tea from Kericho, so I say Kericho tea. I say coffee from Kenya, I say Jamaican blue coffee. a Blue Mountain coffee, it means it comes from Jamaica. When I say champagne, you know it's actually a place. That champagne, that sparkling effect of the wine comes from a place in France, which is a place called Champagne. So then the geographical, as the name just suggests, it means that the indication directly tells us where the product comes from. And so then there are laws that are anchored under GIs that mean that I am not supposed to mislead people and say that this is champagne, so that when people buy the product, think that they are buying champagne from Champagne in France, and yet it is probably just wine from Kenya Wine Agencies, something like that. So then section 40A5 of the Trademarks Act, of our own Trademarks Act, domesticates this section, meaning that we also protect geographical indications right now as collective marks in compliance with the TRIPS agreement. We have a drafting instructions. What that means is that we have come up with a bill. We would desire to have a sui generis law, meaning a specific law that would be tabled in Parliament for the specific protection of geographical indications. It is a wide area, but just for you to know and have a synopsis of what it means, it just means that it's a sign or that indicates where a good comes from, basically from, and it tells us where it comes from in terms of its geographical location. So we talked about, now we will look at what a patent is in details. So a patent is an exclusive legal right granted by a competent, sorry, I can't see myself the full screen, so I'll minimize it. Patent is an exclusive legal right granted by a competent, as I've said, the competent authority is KIPI in this country. So the provision,
Elvine,
yes?
could you maybe use the slide share just to make it a little bit bigger? The size has reduced.
It has reduced?
Yes.
I don't know.
If you click on the slide share, would that work? Try, please.
Let me try. Sorry about that.
No problem.
Slide share. Where is that?
Just at the bottom where your cursor was moving, at the bottom where you have the percentage, so that next to it there's something that looks like a whiteboard. If you click on that.
This?
No, on the other side. Yes, there's something on a stand.
On a
move
stand.
To the next one. Yes, move to the next one. Yes, that one, slideshow.
The slideshow?
Yes, the slideshow.
Oh, the slideshow will throw me out. I'm not seeing everything, but it's fine. Okay.
Okay. Yes, that makes it bigger for us. Thank you.
Okay.
Yes, thank you.
I did that because I was not able to see the whole presentation myself, but it's fine. I'll manage. So anyway, so then we are specifically now talking about a patent. I'm terrible with time, so forgive me, but I'll try. I hope I'm not going too fast. So a patent is an exclusive legal right, as I've said, that the competent authority is KIPI. So the issue is, as you remember, we talked about an invention, that it's a solution, it's a specific solution to, it's a solution to a specific problem in the field of technology. So then we give you an exclusive legal right. And as I earlier said, that a trade secret, when you keep a secret, like most, and this is in the area of maybe traditional knowledge, many people like coming up with medications, like now in this current situation, someone has some herbal remedies that they would perhaps say that can cure coronavirus. And so you're not disclosing to us. So they're the ones who usually come up and say, you have to chant like this, you have to do certain things. So it's not even, some of the things are not even able to be documented. So then this is just the opposite, a patent is just the opposite of a trade secret, meaning instead of people feeling like you need to hide. Why would you hide? Because you feel that when I disclose it, people are going to misappropriate, people are going to misuse, I will not get value for what I have researched and sat in the lab to find out about, probably like exactly what's happening now about the vaccine, the possible vaccine for the coronavirus. People take time to do research. And so what we give in return is that for your sweat, for your time, for your research, all that time you have taken, we give you that, it's like a social contract between you and the government, that you're able to give us and fully disclose what you have come up with. And then at the end of it all, we'll give you 20 years of protection. Then after 20 years, we will allow it to go back to the public domain. So it's a balance. So we give you, for you to recoup as an incentive for all your work. And then at the end of it all, you give it back to the country, so that other scientists, other people in that field of technology will be able to see. And then at the end of the day, we improve technology, we advance technology, and technology continues to grow. As we have seen, we have grown immensely because of the patent system, and I'll give you examples as we go along. So the provisions for the grant this one is charged under the Industrial Property Act and the Industrial Property Regulations, 2001 and 2002 respectively. And I've already said an invention is a solution to a technical problem in the field, to a specific, and it's a specific problem. You can only solve for one specific problem, and another one, and another one, and another one. So you can have varied patterns for different problems that you're solving. It may be a product, meaning it could be medicine for coronavirus. It could be a process. You tell us that if it's a distillation process, from the normal process of distillation, I have come up with this way, or a method of doing something in a new way from what is already known. There are 3 criteria, which are an international criteria that we use to assess whether a patent should be protected. The invention or the solution to the technical problem must be new. This means it's what we call novelty, just a bigger word for new. It should not be disclosed anywhere. And disclosure, as I've said, it means either published, in any publication. It has not been seen prior to the application that has come beyond, and we have agreed under a convention known as the Paris Convention to give a grace period of 12 months. Then it will lose novelty. The whole reason why countries sat down and thought, when I come up with a patent, for instance, today I come up with a medicine for coronavirus in Kenya. And since it's a pandemic and it's affecting everyone, so I would want it to be protected. And it's important for me to say that all these rights are territorial, meaning when I want to go into another territory, Kenya is one of the territories. So I'm saying if I go to another territory as a state, I'll need to protect it within their laws. The international agreement that we signed under the Paris Convention came up so that you do not lose novelty. Meaning when I come up with medication today, the 16th of July 2020 in Kenya, when I go probably to the US, maybe in a few months, as we were doing trials and every other thing, on, let's say, next month on 16th, it will mean that it has been disclosed. You remember I have said it should not be disclosed anywhere in the world. So then it means it was already disclosed in Kenya, so it will fail this test. So then countries agreed that we will be having a 12 months grace period, meaning if I registered it today in Kenya, when I go after 1 month, 2 months, 6 months, up to 12 months from the date that I had my application in Kenya, I will still have, my innovation, or rather my invention should still have the novelty. So that's the reason why. So then if you come anywhere later than that, it will not pass that test. The invention must involve an inventive step. What does that mean? It means that and we call it the non-obvious rule. It means that you have to have done something beyond what is known in that field. If I was to come up with medication for coronavirus, at least now there's none. So you have to tell us, even if you're using something that's already there, that I used this solution and this one, that I came up. So it is not something that can be done by a person skilled in that area, skilled in the art. That's what we look at. So that means that when we talk about an inventive step, if I am coming up with a product, a process, or a method, it must be different from what is known. We invent from what is known to the unknown. We are coming up with something new, and that is why you're being given an exclusive legal right for your protection. So then you must justify from what is known, that this is what is known. So if I'm a lawyer, for instance, if I'm coming up with anything, it's not something that we were taught in class, an ordinary lawyer would do. So if I'm in mechanical engineering, and if you're in any other field of technology, a chemist, then it must be something that is beyond bookwork or what was taught in school. Then the invention must be industrially applicable. It just must be useful, meaning it must be mass produced. When you tell me that you have an invention and part of the medication for coronavirus, I have to go to the moon to get it, then it means it's not useful, it's not accessible, it's something that we are able. And at the end of the day, what we are talking about when I say that it's granted for 20 years, then after the 20 years, it goes back to the public domain. The whole rationale is that you must disclose it in a way that it has to be reworked without coming back to you. Meaning I don't have to come and ask you, what should I do here? You disclose it fully in a way that someone skilled in that area can be able to read the invention and be able to work it out without further reference to you. So that's also very important. Then we grant patents under a national regime. Under our national regime, we also have a treaty which we call the Patent Cooperation Treaty. I've talked about territorialism. We do not, every right has to be registered within a territory. So the Patent Cooperation Treaty is a filing system that allows you, if I'm to come up with medication, or anyone comes up with medication for coronavirus, as we are now seeing, if then it comes from the US, for instance, they will come under the PCT. From the US, they file, then they want to protect it in all these countries. So you come under the countries so that we also vet it and take it through our laws, and then it's approved. WIPO is the African Regional Intellectual Property Organization. This is an organization. So the Patent Cooperation Treaty is a world, it's the coverage is for the world. So there you access the countries that are signatories to that treaty. WIPO is an African regional, as I've said, an organization that brings up the African regional countries. So then you also have access to register. It's a filing system. It's a faster system for you to use one of the countries, and Kenya is also a country of origin. That's what we call it. So the application comes from Kenya, then you can be able to designate the countries under the treaty that you are interested to protect in those areas. So yeah, so we have a national, we have an international, and we have a regional way of protecting patents. So yeah, so what am I talking about? So I'll give you an example of a product, so that we are able to kind of now get the definitions and look at a simple product that can be patented. So this can be a door lock. When you look at a door lock, someone thought about a problem that when we are in the house, maybe because of security, we may need to lock our doors. So that's a solution. So someone comes up with not only even the door itself, coming up with a door as a protective measure, a security measure for people to come in and out. Then that could also be a product, a lock in itself, that I need to lock So the lock itself is a product. So it will go through the three criteria. We have to check whether it is new, it is non-obvious, meaning it has an inventive step, and it is useful. It can be mass-produced. If it's a composition, then it could be in the same, I'm using the same context of the lock, then it could be a chemical composition in lubricants for door locks. The problem is sometimes you can see that the locks, they rust and they become cranky. Some of them make a lot of noise. When we open, it's clanking. So then it means I have come up with a solution to come up with a lubricant, which now is a chemical composition. So that could be a process or a method of coming up with a lubricant, which we have to go through the criteria again to see whether it is new. So you have to tell us that there's nothing of this sort. Maybe if it's oil, you know, some of us use oil, then you have to tell us how you've come up with this one, whatever you have concocted within your solution that is not there, and then it can also be mass produced for use in the industry for locks. Then an apparatus, it can be a machine, which is also a product, a machine for making door locks, meaning I have come up, you know, the first person came up with a door lock, maybe he made it through Juakali or whatever. So someone has come up and thought, it is so tedious for us to make one lock. So I have come up with a machine. So this is also another patent. I have come up with a machine for making door locks, meaning it's faster, it's less, you know, it takes for you to produce more. So then we look at it again and see whether there's ever been a machine. Is it new? Does it involve an inventive step? Of course it is not. Is it non-obvious for a person skilled in the art? And then we look at its usefulness and that which is industrially applicable. Then it could be a process. We've talked about a product, a process, or a method, an apparatus. So a process would be a method of making door locks. Maybe there is a specific way. There's a way you put in the lock in a certain way. So I have come up with a different way that maybe now I don't need a key. We've seen locks that do not need keys because probably people keep forgetting. I keep forgetting like this one, I keep forgetting. So I just need to clank it and move it. So it's a process of making a door lock. Then it means it has to go through the three criteria again. If it's an improvement, and by the way, 90% of the patents that come up are improvements. Even if you look at the aeroplane that I gave an example about, it was, you know, it has evolved. When the Wright brothers started, it started off. Now we have seen different things coming up that you can put our luggage in flight. You can slant your seat when you're sitting. You can watch television. Some are industrial designs, some are patents. So we are able to see how improvements on existing patents can also continue to evolve. And that's the rationale. That's why we give protection, so that people can be able to think and give us better solutions and advanced technology. So then we can look at also a pictorial of how our phones have evolved. You can look at the ones during the 1930s, then it has evolved to the 1950s. Probably before 1930, people were using smoke signs and all that. We learned in history. Now we have evolved to the one in 1970. Then we remember our Motorola flip back. Now we have the iPhone, we have touch screen. All these are advents of technology advancing. So the person who started in 1930 probably is the one who gave us the idea of a phone. So then people, as they disclosed and gave the full specificities of how they came up with it, people continue to evolve, and the phone has evolved. Now we have a camera, we have, you know, it's like a walking laptop. We have a camera embedded in a phone. We have so many other things. You can access your email. All these things have been embedded as a result of the advancement and improvements of existing patents. Yeah, so then another area would be of interest would be sports, you know, just And patterns go into everything. Whatever you think about, when we wake up in the morning, the bed you're sleeping on, someone came up with a solution that, well, probably we were sleeping on the floor. Then I thought of, let's come up with something soft that would be able to help us sleep well. Then we came up with a mattress. Then once you come up with a mattress, then you're thinking, okay, our backs need protection. So someone comes up with springs, and then people think, the springs are not good for our backs. So it's evolving, every day evolving. When you wash your face, someone came up with soap. They thought, we get dirt, it gets dusty, and we need to wash our face, we need to brush our teeth. We started with, what are these called? The sticks that would just rather brush with nothing, with water, probably with salt. Someone thought about salt. Then we thought, let's come up with a decent way of doing it. Then we come up with a toothbrush. We came up with toothbrushes that now can reach to the back of our teeth, that bend, and they are soft. When they started, they were a bit hard. Our gums would bleed. So all these are improvements of existing patents. The person who started with the groundbreaking patent, and continually we have continued to evolve, and now we have better, and technology continues to advance. So for this, I just gave like shoes. We have seen this patent was issued in 1921 for basketball. You can see the spikes down there to enable them to have stability and a lighter shoe. And where the weight of the shoe is reduced to a lighter insole. So there's an insole to protect the feet from the spike pressure while stepping. So then they put an insole inside. So all these are aspects of patents. You know, someone thought about it, probably you'd start without shoes, our feet get cracked. Then someone came up with the idea of a shoe. Then now we go into sports, we are thinking when we are running, it's too heavy to wear. We have different kinds of shoes. And in the sports arena, even for our clothes, it would be absurd for me to swim with the clothes I'm wearing today. Someone thought of a swimming costume, a swimming cape for the girls, for the ladies, for our hair, you know, swimming goggles to protect our eyes from becoming red. So these are solutions continuing to advance technology. So yeah, I had an example also of a treadmill in the sports area. You can see the basic treadmill. When it started, it was just a treadmill. Now there's so many things we can access, workout results, you can program interactive courses, Bluetooth, there's Bluetooth connectivity for you to listen to music. You can be able to look at your pulse rate and your heart rate. All these are solutions that are embedded within a machine, which continues to help us get better. So what is the procedure like? So these are the filing fees. We have a filing fee, which we will do a prior art search to check against the criteria I talked about. Then we grant, hopefully, if your patent qualifies. So it confers, as I said, exclusive rights on the patent holder for 20 years from the filing date, subject to renewal. So you have to renew and pay an annuity fee. The annuity fee continues to rise as you go towards the 20th year. So it's just an assumption that you're making more money as you continue to grow in the market. So it becomes a bit costly. The claims, there's something we call the claims, what I've talked about. When we are looking at novelty, for instance, if I came up, I'm the first one who came up with the treadmill. Then someone else came up with the aspects of the heart rate and heart pulse, that it can pick the heart rate, and which could be a method or something within the treadmill. Or in our phone, I came up with the idea of a camera. It may be, so we have to look whether it is non-obvious or obvious to a person skilled in the art. And then, so then it means the scope of protection is for what was new, not the whole thing. So we break them down. When you're making an application, you must specify, and this is where the rights accrue. And this is where there's the point of contention when you go to court. We will not look at the whole thing. You know, if a shoe was invented by someone, for instance, then now for me, it was the spikes. So my issue, the claim would be for the spike and not the whole shoe. So when I go to court on an infringement case, then I would narrow my argument on the spikes and not the whole shoe. So this is a very important aspect, especially in dispute resolution, because this is where it's like your fence. When you're in your land, it's the boundary, it's where the beacons are for your protection. So it's a very important issue for people to be able to now remove the issue of the whole invention and now narrow down to what exactly was protected. That's what we call the claims. Improvements or development of earlier patents, which now I talked about. We remember we talked about utility models. A utility model, when we look at the 3 criteria, we have it's either new, we said it's either new or involves an inventive step or industrially applicable. The second criteria is not needed for a utility model, that it might not be non-obvious. So the issue is when that's why they're called petty patents. They're given 10 years because that one is not, it's not mandatory for you. Non-obvious meaning it's something that has improved. For instance, when the toothbrush was made, or rather was invented, the person who invented the toothbrush came up, was granted a patent. Then as we used it, we had probably had bristles. So I come up with softer bristles. So my claim would be the softer bristles. So when we look at it on the aspect of non-obviousness, it means it's not rocket science for you to come up and think that because the bristles are hard, I make them soft. So then you'll get a utility model for 10 years because you've modified and improved the utility of an existing patent, but then you will not be given the patent. So these are small modifications. These are improvements on existing patents, and that's why they're called petty patents. For instance, like people coming up with these GCOs, energy saving GCOs. Maybe now you use a different kind of fuel to control the amount of energy that goes out. You are not the one who created the GCO, but you have come up with a solution to better the utility of that product. That's why it's called a utility model. Yeah, so either way, for patents, for trademarks, for utility, all these exclusive rights, if you're to obtain them, we have said that the exclusive rights, they must be either by license or either you have bought and then, you're either paying royalties or you're completely buying off that patent or that trademark or that utility model or industrial design from the owner. So that's the protection they have. They have the exclusive right. No one can manufacture, no one can license, no one can use their product without their permission. And permission, in most essence, connects to money. So we talk about trademarks. So trademarks are administered under the Trademarks Act, which is Cap 506 of the laws of Kenya. So as I earlier defined, a trademark includes, this is how it is defined, a distinguishing guise, a slogan, a device, a brand, a heading, a ticket. It can be a name, a signature, a word or a letter, a numeral, or a combination of all of this, whether rendered in 2 or 3-dimensional form. So what are we talking about? A trademark, you know, as I've said, it's a sign. It can be a slogan. We look at them, then you'll be able to distinguish. It can be a device, and we know them. It can be Elvine. We've seen people calling their trademarks. I think you know Coco Chanel, Gucci. These are people's names. I can have Calvin Klein. So it can be your name. It can be a signature. But as you remember, I said that it should be able to distinguish a product from or a service. When we talk about a trademark, it's for both. It's either a service or a product. So then it means it can be able to distinguish me from one party to another. So if I'm a mediator, for instance, I want to come up with my own practice, I can be able to say Elvine whatever associates the way we do it as lawyers, so that you distinguish me from other lawyers. So you are able to choose in the market as we trade to be able to know where you're going and whose services you're seeking. So it is either protected when you have used it or proposed to use. This is a major difference. For patents, it's fast to file. You remember I told you, even if we come up with medication today for coronavirus, then if it's protected, we look at the dates. It's the person who is fast to file, meaning the person, it's assumed that whoever creates something would know it fast. So then it's called the fast to file rule. The person who comes to the office first is assumed to be the inventor. But for a trademark, you can be able to register even after you have used it, meaning it's fast to use. You can be able to use, so that's why the law says in section 20 that it's either a mark used or proposed to be used. You can be either just launching out a mark, or you've already used it and you want to register it. So then, as I've said, it shows a connection between those goods and the owner. So it's a badge of origin. That's what we normally talk about. So when we look at these trademarks, as when we're looking at the definition, so it could be, when you look at KIPI, we have KIPI. So those are, it could be letters, then it could be numerals. I don't know if you've ever seen 7-Up. It could be numbers. It can be Puma, as you can see the leaping animal there. It can be the swoosh sign of Nike, just in itself. When I look at it, you don't have to tell me that's Nike. When I look at the Mercedes-Benz, when you look at the name itself, then you look at the sign. It can be both. You can see some of them. Coffee Kenya, it has the seeds of the coffee beans. Then it can be both. It can be K, which is Kenya Airways. Then I said it can be a slogan, the Pride of Africa. Sometimes when I just say Pride of Africa, you'd know what I'm talking about without me saying KQ, you know, or if I say KQ, or I say Safari, the better option, you don't need to you immediately know what I'm talking about. So then these are a representation of, you know, either trademarks. It could be a bottle, it could be the device of a car, which is the two-dimensional or three-dimensional aspect of that definition. So the trademarks include service marks. So I talked about it's either a good or a service. A trademark can be for a product. It can also be for a service. For lawyers, it's services like legal services, transport services. Then it can also be for a good like perfume, soap. So those ones are goods, those are products. So it can either be for both, and they are territorial. Trademarks are protected in the scope, in the territory, that's the scope. So then as we've defined it under section 2, there are different types of trademarks. So there are collective marks. Collective marks are, as the name suggests, they are marks that are not individually owned. It means that these are probably an association. Like for instance, now matatus have to have a SACCO. So when they want to differentiate themselves from one, that's a service. So you want to differentiate, maybe there's Umo Ina, they want to differentiate themselves from Double M, which is also a trademark. You come up, and so when you come, you're coming as an association, you're not coming as an individual, so it's a collective mark. So the mark can be used by the people who have been, who are affiliated to the society. So if it's the legal fraternity, maybe it's the LSK. If it's mediators, if you have a forum, you have come up with one mark that each one of you can use. It distinguishes you from other enterprises. People are able to distinguish you, then you can come and register as a collective mark. So a collective mark comes along with rules of the association, what entails someone to come into the association. So then, because it's not an individual right. Well-known marks are marks, as the name suggests. These are well-known. They have a higher protection. You do not need to register them for as long as they are, because of their notoriety. If I talk about something like Coca-Cola, it is well known. People, whether you register it as a matatu business or as a, you can argue that we register marks under classification, we call it the NIS classification, where we have a classification for administrative purposes. We separate goods of different kinds of descriptions. So then if an argument would be that I am making juice, so I can be able to use, you cannot be able to use Coca-Cola. And probably when I'm using another mark, I can be able to use a name in a different class. But then for well-known marks, because of their notoriety, even if they are registered for different classes, people will still think there's an association. So then we know them. It's probably Nike, Adidas. Those ones cannot be registered by anyone, whether they're registered in Kenya or not, because we say that registration is territorial. They have to, because of their notoriety, they cannot be registered by anyone. Certification marks. These are marks that are given by a certifying body. A good example would be the KEBS mark, which is registered with us. It tells you of something, it tells you of quality of products, that it's good for human consumption. We look at that standardization mark in all our products, and it tells us, so it's a certifying body and it comes with the rules that certify whatever it is. So if it is LSK, that would certify probably lawyers. If it would be for accountants, the same thing. So you're a certifying body, so you have a mark that people would use to verify that these products have been certified. Then we also have an international system of registration. Just as under the Patent Cooperation Treaty, we also have the Madrid system of registration, which, as I said, all these rights are territorial, meaning if you want to extend your protection beyond our territory, you have to register within those territories. So countries came up with an easier way of registering these trademarks. So we came up with the Madrid system of registration through the Madrid Agreement and Protocol. Now all the countries who are signatories of the Madrid Agreement have moved to the protocol. And Kenya is also a signatory to this protocol. So it means you can come and have an application as a base application in Kenya. Then we have the World Intellectual Property Organization acting as a secretariat for us, housed in Geneva. So they'll be able to take and you're able to have our application or your registration in Kenya as the country of origin, and you designate all the other countries that are of interest to you. And it's an easier system of filing instead of going individually into the countries. So you have a secretariat handling the protection, or rather the registration procedure for you. And so you can have registration once it has gone through the national procedures of the different countries designated. The important criteria, and this we'll talk more about when we are dealing with dispute management or dispute resolution in our afternoon session. So the Madrid, then there's the important criteria we look at is your intention to use the mark. It has to be bona fide, meaning you have to have good faith to use the mark. So we've said that you need to be for you to claim to be a proprietor of a mark, you must have used or proposed to use a mark. So that means that if someone is not using the mark, it can be removed from the register for non-use, meaning you do not just come and hold marks and have them protected and you're not using them. So then when we examine marks as part of the procedure, when you do a search for us to check for you whether the mark is available, it must not fall within the absolute or relative grounds of refusal, meaning it has to be distinctive. Distinctive, I mean, when I'm looking at, we said it could be a name. If it's Elvine, we are looking that it's distinctive in itself. If I come up with a name, for instance, like Kitui honey, Kitui honey is not a distinctive mark, because at the end of the day, everyone is allowed to use Kitui. There are certain words that we do, and honey itself is describing. That's the second, the other element we look at. When you're describing a product, then there is no innovation in terms of what you're coming up with for you to be given exclusive rights over a word. So we do not give exclusive rights to common words in the area where I've talked about the administrative tool we use, which is called the NIS classification. So for instance, if I am looking at tea, which is in class 30 of the NIS classification, which is tea, coffee, and food products like that. So when I'm registering tea and I call it Kericho tea, everyone from Kericho would also want to use the name Kericho, so we cannot give you exclusive rights over the word Kericho, nor tea. Tea is describing the product. So then you can see then at the end of the day, your mark may be refused for it lacks distinctiveness. But maybe if I say Elvine tea, or Melvin's, I know you know about Melvin's tea, it's close to my name. So when we say Melvin's tea, then she has made it a bit distinctive, because then it describes Melvin, which is rather, it talks about Melvin, which may not necessarily be describing the product. Then we also look at prior user or earlier rights as against when two, and this we'll talk about in the afternoon, when two people come in, one is registered, probably you knew about KIPI and you came and registered, the other one is not registered. So what does that mean? We will look at who, as I said, we look at first to use. We will look at who came into the market first, so that you don't go and copy people's marks and come and register them as your own. So these are earlier user rights, which ideally, what I'm talking about is section 12, section 14. We also, in section 14, we look at what is morally right. For instance, for us, when we are considering a trademark, for instance, when you're considering a trademark in Kenya, or maybe when we go to Tanzania, it might be an abusive language. So we look at also issues of public morality and things that can be registered. There are some images that are offensive in our territory, and some may not be offensive in the countries they're coming from. We talked about the Madrid system, the international system. So when these things are coming, especially from our experiences from Japan, most of the trademarks are very abusive in the Kiswahili language, but in Japanese, they are very innocent words. So then when it comes into our territory, we might not accept it under that section in terms of public morality. And you know, and just, we will not allow it for the common good of our nation. So then section 15 is now anything that has been there before, in terms of we will not register something that is similar or deceptively similar to another mark. For instance, if I was to register a trademark with CIFA, we look at the visual element, and I think more of this we'll talk about when we are looking at dispute resolution in the afternoon. When we talk about something like CIFAR, S-E-E-F-A-R, and C, which is the letter C, and then FAR, F-A-R. Both under our regime would be phonetically, or rather, it's we say it's phonetically similar, meaning they are pronounced the same. So whether I say CIFA or CIFA, and it depends what products they are. Sometimes if you're dispensing, for instance, if it's medication over the phone and it has such similarities, we will not allow those marks to coexist in the register. So we will talk more about that when we are talking about dispute resolution. So how does the process look like? We start with a search. We do a trademark search, starting from the left going towards my right. Then we do the trademark application. So a search is important so that we are able to check the database against the tool, that the administrative tool I said, which is the NIS. It's an international classification system that we use to check when I want to do perfumes, I check under class 3. If I want to, some of us have very powerful names. Maybe you have a similar name as Coco Chanel. So we will check and see there's another Coco Chanel on the register under class 3 for perfumes. So then we will advise you at the search that it's not available for registration, and you can give a defense So that is what is called written submissions or ex parte hearing down on the left of my presentation, meaning that someone is, because of some conditions or something that we have refused, you may come up and say, so this is, we will talk about it more in the afternoon in terms of how someone can be able to come in and bring objections as to what the registrar has either refused or suggested a condition for you before your mark is registered. Application, then we go to the trademark application. Searches are done for different reasons. Sometimes someone has written a cease and desist letter and told you to stop using their mark. My name, probably the Coco Chanel herself has seen you using her mark and said, stop using my mark. Then once it's done, once you get the letter, you'd come to us and ask us for a search just to ascertain that it's registered in KIPI. So at that point, you're not coming to register a trademark. It's called a proprietary search. You just want to know who the owner of this mark is and whether it's legit, what they're telling you to, when they're telling you to stop using the mark or not, so that you can make a decision as to whether you follow the legal procedure or you stop forthwith. So then at this point, searches can come and disappear. Sometimes we can say that you have done a search and we tell you it's not available and you never come back, to register or do a formal application. So at the point of search, it's non-committal. So we don't even open a file. So the trademark application, that part, when you file the form for application, that is when now you have committed yourself. And so at the end of the day, again, by the time you're doing a search and you're doing the application, we'll have to go through the database again, just to ensure that things have not changed. So then the trademark application is done. Then a formality examination is done to check against whether the mark is distinctive, descriptive, whether it's a common word in the area. For instance, if you're doing maybe like drinking chocolate and you have illustrated a device of a cup, and people in that line of products would also want to use things that are common and not given, someone is not given exclusive rights. So we may tell you to disclaim the exclusive use of certain elements. If you're using a device of a human being, we do not give that. For instance, the flag of Kenya, we are all Kenyans, we may want to use the flag. It's not allowed. In fact, it's prohibited. We do not allow the use of flags. So you can use in different colors, but not in the color of our map. So we'll tell you at the point of formality. Formality examination is just checking whether the fees have been paid, the application is proper. Then when you get to substantive examination, we look at the elements I've talked about. Then we publish for 60 days. Upon the 60 days, we are telling, in our industrial property journal, we are telling the public that this mark has been registered, so they are able to oppose it. That's what we call opposition proceedings. And then if within the 60 days, no one comes up to say that they are objecting, then we'll give you a registration certificate. But there are certain times that within the 60 days, someone probably did not see. So then that is where we have these expungement proceedings. You can come and remove the mark from the register. So these ones we'll talk about it more during dispute resolution or management in the afternoon, so that we can see how the disputes are handled. And yeah, so this is the place where the Act, under the Trademarks Act, the managing director of the Kenya Industrial Property Institute is the registrar, and then he can have deputy registrars or assistant registrars. And so this is where I'm also an assistant registrar of trademarks. So we sit to hear matters in relation to trademarks and come up with decisions that are appealed at the High Court. So at this point, that is where we come up with, and that we'll be talking about more in the afternoon. So just the basic fee for trademarks as such, which I have talked about, is 3,000 if you're doing it for one class. Subsequent classes, meaning that you, for instance, I want to come up with Coco Chanel again for perfume, but because my name is well known, I also want to make t-shirts with the same name, Coco Chanel. So perfumes are in class 3, clothing is in class 25, under the NIST classification, which I've told you is an administrative tool we use. So you'll have 2 classes. So you'll pay 3,000 for the first class. Any subsequent classes, if I want to also use it for my letterheads, which is in class 16, I'll pay 2,000 for class 25 and class 16 and like that. If you're a foreigner, you pay in US dollars, and yeah, so for the first class and every subsequent class is a bit cheaper. So it's an incentive. We are a multiple class. That's what we call a multiple class registration system. We can be able to have one mark in different classes. For instance, Coca-Cola can be registered for soft drinks under class 32. It can also be registered for t-shirts and clothing apparatus under class 25. They can also use it for their letterheads in class 16 like that. So all these are distinct. It's the same mark now for different services and goods. Then the formal application after the search, I've said after search, someone may not be committal. So at the point of now, the formal application is from TM2, you pay 4,000, and the same, if you're doing it for more than one class, the subsequent class will be 3,000. So the same for US dollars if it's a foreign, and this is a natural person or a legal, in legalist, it's a legal entity. So a company, if the company's address is a foreigner, you will pay in dollars. The person who is applying is what determines how the rates will be. Then we'll pay for publication, which is advertisement. You pay 3,000, and then for the subsequent classes, if you have subsequent classes and like that. So registration is 2,000. So basically, if you're applying for one class, you'll pay 12,000, which is very reasonable, and the protection is for 10 years. All our fees are on our website. The schedule is there, so you can be able to interact for all the other things that we do. I also wanted to flag out well-known marks because it's an important element, and we'll be talking more in the afternoon about it. These are protected even if they're not registered. So this is also a bone of contention. Sometimes when disputes arise and someone comes up and says, no, it is not registered in Kenya. If, for instance, I know there was a time someone wanted to register Manchester United for sweets and we refused, and you're furious because you've not seen it for sweets, it's not allowed. Under the Paris Convention, which we are signatories to, you tell it has to be protected under Section 15A1. It's also protected under, it's incorporated in our law. So we also recognize well-known marks. So the grounds to be considered are included in WIPO. WIPO is the World Intellectual Property Organization Joint Recommendations. We use this as a guide. We look at the duration. We look at the extent of the period that it has been used. We look at other jurisdictions that it has been adjudged, that it is well known. We look at there are certain international brand gradings, for instance, where they say Coca-Cola is #1, #2, so you have been adjudged that you're a well-known mark. We may also use that as persuasive when we are coming up with a decision as to whether the mark is well-known, whether it is registered in Kenya or not. But believe me, that most of them are registered in this country, though they have that protection. So the degree of knowledge, that's what I was talking about in the relevant sector. It has to be in the relevant sector. As I've said, we look at trademarks within that administrative tool. So we don't look, if I'm talking about cars, if I say Mercedes-Benz is a well-known mark, it has to be within the sector of automobiles, not for food, for instance. So it has to be for the relevant sector that we are talking about. So the average consumer who buys cars would be able to know a Mercedes. So that is how we come up with that decision. So the duration and extent of geographical area, how vast has it been used, the promotion in terms of advertisements, the extent, the publicity that it has taken, and then if it has successful enforcement in other jurisdictions, even if it's not in this country, would also be persuasive in terms of giving protection for well-known marks. The classical case, which I will talk about more in the afternoon, is McDonald's versus Joburg. In this case, this was a South African case. So Joburg was coming up with using the mark McDonald's, And now the argument was that it's not registered in Johannesburg. So now the determination was that whether it is registered or not, under the Paris Convention, what we were talking about, it must, because of its notoriety. And they looked at what I was talking about, the relevant sector, are people who are well-versed, who are well-traveled, who would know the McDonald mark, the golden arches, if anyone would know it, they're called the golden arches, the ones that create the M. So then in that territory, it was allowed, though it was not registered. So that's the kind of disputes we go about, but now the basis would be because it is well known, and not well known to everyone, well known to the specific sector. So then examples would be like Nike, Adidas, Manchester United, Safaricom in Kenya, probably Kiwi, Nescafe for coffee, Coca-Cola, you know, certain marks that have reached the notoriety. When you talk about them, people would immediately associate it with a certain brand or a certain company without thinking twice. Then it means it has a higher protection. Some of the marks, by the way, even sometimes they may be identical, but because of the diversity of the classification, maybe I am using my mark for air cargo and the other person is using it for cars and motorcycles. Because these two people will never meet, the average consumer in these two may never meet, it may be allowed. But for a well-known mark, we never allow them, whether they are in the same class or not. The aspect of territoriality is lifted for well-known marks because of the repute, and it means that the repercussions are dilution. When we give you that mark, it means you will dilute it. Maybe your products will be terrible and you will now begin to, you're riding on someone's reputation and mess up their reputation as well. So I think this is now the end. I just wanted to give a synopsis of what we're going to talk about in the afternoon. At the end of the day, you cannot give rights without someone enforcing those rights. And that's why I just asked the question, what is enforcement? It's the act of compelling observance or compliance with the law. You know, just regulations and rules. Or, you know, at the end of the day, when we are, the incentive is the government is protecting industrial properties, the ones I've talked about. We are giving you exclusive rights. And then we, under these acts, make people obey the law, so that it means you can enforce your rights. This is the icing in the cake. At the end of the day, it would be a useless paper when we give you a patent, when you give you a trademark certificate, and you're not able to enforce them. So it's implementation, and effective, successful implementation depends on the dispute, you know, mechanisms we use and the resolutions that are given. So we enforce the two acts of parliament, which we've said is the Industrial Property Act. There are offenses within which, if someone uses your exclusive right under the Trademarks Act, what is allowable, what is not, and all this we are going to talk about in the afternoon. Our anchor, as we earlier talked about, was the Constitution under Article 45, and it's a very important anchor, because then we have given intellectual property right its rightful place, and in the Constitution, you know, in the Constitution, those rights are undebatable, that the state has said they shall support, promote, and protect, you know, intellectual property rights of Kenyans. So that it's administrative protection through KIPI. We'll talk about it in the afternoon. I talked about opposition proceedings. How do we do it administratively as registrars? We've talked under the patent system. We also have the Industrial Property Tribunal, where when we've granted a patent, if you feel that it's not new, it has not followed the criteria we talked about, it is obvious, rather it did not fall under the non-obvious rule, and it's not industrially applicable, you can go to the Industrial Property Tribunal, seek for revocation. We'll talk about that in the afternoon. So there are civil remedies, there are criminal remedies, which we'll talk about in the afternoon in terms of dispute resolution. There are border measures, in terms of custom and enforcement officers, how we work with the anti-counterfeit agency, with KEBS and KRA, in terms of someone using a mark, what is the implication of you purporting that this is the mark, and what are the differences in terms of what is a counterfeit and what would be trademark infringement. I think I'll give time for people to ask questions if they'll be able to. Thank you very much. I was hoping that we'll have a bit more time. I had said earlier that I'm terrible with time management when I talk about IP. I'm seeing it's 8:30.
Okay. Well, Elvine, thank you very much. I think you've taken us through quite a detailed session. We do have a few questions and comments that have come in the chat. So I'll just quickly read through those. I believe probably there will be an opportunity to address some later on, but just, for you to know. So some of the questions have been, one, you mentioned KEKOBO. So what is the place of the Performance Rights Societies of Kenya? What is the place of the Music Copyright Society of Kenya? The other question was, what is the role of registrar of companies when it comes to all these registrations? The other question that came up in the chat was the issue of the chair that we saw in the social media recently, and the order for the hospital beds that the president made recently. Are these things that qualify perhaps for utility model? Then the other thing is, when there is, from the example that you gave, who has the rights? Is it the employee who has the rights? Is it the employer who has the rights? So those are some of the things that have actually come up in the chat. So you could briefly respond to them. If there's things that we're going to be looking at in detail in the afternoon, you can mention that as well.
Yeah.
And then we will be able to close. Yes.
Okay, thanks. I'll quickly go through what KEKOBO, the Kenya Copyright Board. I think that was the first question in terms of where the performers' rights, MCSK. These ones are all managed, and I have not come in. I should be very clear that I work for the Kenya Industrial Property Institute, so I'm not speaking on behalf of KEKOBO. These are, as I said, the copyright laws are administered by the Kenya Copyright Board. The MCSK is a collective management society that is licensed by KEKOBO. So what they do is they collect on behalf of right owners in terms of musicians. So this is MCSK. Performers also have their own collective society, or rather their own society. So then they are under an umbrella. So all these are managed under KEKOBO, not KIPI. So unless we say chat, so I cannot speak on their behalf, but basically that's what it is. So whenever you hear the call logs, or rather the music, are they called logs? When someone sings in a radio, they manage for you, and then you're paid your royalties. So it's the same thing as we said, intellectual property is exclusive, right? So at the end of the day, everyone has a right to, when you use someone's song, or rather they play the songs, as radio stations, they need to pay the owner. So when you use it in hotels, in public places, spaces, you're not allowed to use it except with the permission of the owner. So the same thing applies. So there are exceptions in terms of, like, now if I was to use music rather for education purpose for my own private use, that's okay. But when I'm using it for commercial purposes, then you'd go under. So the MCSK manages such collections, and then at the end of the day they remit to the right owners. Then now the registrar of companies, I think that was the other place. Where is our place in terms of the registrar of companies? Our relationship is that these are different acts. The registrar of companies is legislated under the Companies Act. We are under we administer the Trademarks Act and the Industrial Property Act. These are different. We look at different aspects. If you were listening to the presentation, I was telling you CIFA and CIFA would not pass under the Trademarks Act. Probably when you go and search under the Companies Act, both of them would, as a company, because what the registrar of company looks at is the legalities. That's why you're asked to bring a memorandum of articles of association. We want to see whether you are, you are not Mongiki, you are not coming up with sects here to, what kind of work are you involved in terms of the legality of the enterprise you're bringing forth. Us, what we are looking at is the name, the trade name, and how it's going to relate with other trademarks in the market. So we are working, there's a coherence, I agree, in terms of the same, like Coca-Cola is a company. Coca-Cola is the company name and Coca-Cola is the trademark name. So we are looking at how we can be able to work together in terms of reducing the confusion in the market. But at the end of the day, the registrar of companies has a different mandate and the registrar of trademarks has a different mandate, as we have been empowered by our separate acts. When we talk about the chair and the beds, I specifically talked to the person when it was trending on Twitter. We have to look at the criteria. I don't know if you remember. So we have to ask ourselves, is it an industrial design? Is it a patent? Has there been a chair before like that? We spoke to the person. He copied it from, and if you look at it, we looked at industrial designs, it has to be new all over the world. So the criteria is the same, whether it is our local people or whether it's the foreigners. So what we look at is it cannot get to the threshold of a patent if we've gone through the criteria. If we look at a utility model, maybe. We talked to him. Some of them are not interested in registering the patent, or rather the utility model. You can register it as a utility model. It can also probably as an industrial design if it has not been disclosed anywhere, but I think I saw one somewhere in China or somewhere in Europe that looks like the same, a replica of what has been there. So then we have to take it through the same criteria at the end of the day. So the same for the beds. As I talked about, then if it was not a groundbreaking, you're not the one who came up with the bed. If that aspect of going up and down was already there and it's already there, most of you have seen in our beds, you're able to, when you're in hospital, you're able to take yourself up and down. So as I said, the claim is what is important. Whatever is new, you have to bring to us what is new so that we are able to check through the criteria, whether it's a patent, whether it's a utility model or an industrial design. It has not been disclosed anywhere in the world. So you tell us what aspects of the shape and configuration that you'd feel it would qualify. Yeah, so then employee or employer, I think in my understanding, the issue would be under the Industrial Property Act, when acts are commissioned by an employer, the employer owns the patent. And I think that's very important. For instance, if I'm a researcher in a university, my work, I am employed to research. That is my job specification. When I come up with an invention, when I am researching, that invention belongs to the university. I can be named as an inventor. There is a right under the act that says that you have a right to be named as an inventor, because it has to be a person, either one or two, but the ownership goes into the company unless otherwise stipulated by a policy of the university. That's why we have IP policies and IP agreement. But at the end of the day, the law says that the one who commissioned the work, it belongs to them. So if I'm a lawyer, for instance, now, and I come up with an invention in my office at my own time, not at my employer's time, I come up with an invention, then that will belong to me because my job specification is not to invent. I am supposed to give legal advice and do other things that as specified in my job specification. That's the way I would clarify it. So if it's an employer-employee relationship, it must be very clear, and it's very important for people to come up with proper agreements when you're coming in terms of who is commissioning the work, what will belong to who. You know, that is that's also a very big area of dispute, which we will be looking at in the afternoon when we talk about dispute resolution. I think in a quick synopsis of the questions, I don't know if there's anything I left out. Maybe you'd tell me.
Thank you, Elvine. That pretty much covers all the questions that have been in the chat. Probably participants, we are grateful for you having joined us this morning for the first session. Just some information to share before we close this session. This was the first session of the masterclass that we are having today. As mentioned earlier on, just a minute. Okay, so what we have just gone through is the first session of the masterclass, which was basically the introduction. During the second session, which will be running from 1:30 up to 3, we have the dispute management and case studies, and then the last session will be running from 3:30 all the way to 5 o'clock. Just a reminder that if you're able to attend all 3, then there is a certificate for you. You need to indicate the appropriate names for your certificate by replying to the email that you received to be able to log on to the session this morning. Once again, Elvine, we are very grateful for your time. I think most of us have a good understanding of what you have now, shared with us this morning, and we're looking forward to the afternoon segment where we'll be able to delve deeper into some of the practical issues that happen and where we as mediators can be able to come in. Mediators, thank you very much for joining us during the morning session. We look forward to having you again in the afternoon. And I think we will just conclude as we normally do by saying our prayer, reciting our prayer in Kiswahili this time. E Mungu, nguvu yetu, ilete baraka kwetu, haki iwe ngao na mlinzi, na tukae na
undugu,
amani na
uhuru,
umoja, raha tupate na ustawi. Okay, so thank you very much. Have a good rest of the morning, and looking forward to having you back at 1:30.
Thank you. See you in the afternoon.
Thank you. Thank you so much. See you in the afternoon.
How can we get the note? The very